Okay, I think we're about 1 minute in. I'll go ahead and kick us off. Hi, everyone. My name is Elaine Harwell. I am an attorney at the law firm of Procopio, Corey, Hargreaves, and Savage. And my area of practice is data privacy. And I'm here today to discuss and serve as a moderator to two great panelists here. We have Jackie Aguilera and Jason Mills. And I'm going to let themselves introduce them in just 1 second. And before we get there, I wanted to kind of intro the topic and talk a little bit about CLA's privacy law section. Some of you may know the privacy law section is a brand new section to CLA, started up in 2020. And at this point, I believe we have about 1,000 members, which is pretty good for a brand new section. And someone will correct me if I'm wrong, but I believe still this year for 2021, you can sign up to be a member for free and get the rest of 2021 for free as a section member. So just wanted to let everybody know that at the top here. And we're here today, of course, to talk about the COVID-19 and the implications for a return to work, privacy considerations for California employers and employees. And with that, just a couple of things to note. We are looking and reviewing the Q&A. So if you have any questions, feel free to drop them in the Q&A and we'll try to answer those either along the way or at the end when we reserve some time. And then also with regard to the PowerPoint that we're going to have today, it will be either emailed to all the participants or we'll try and drop it into the chat as well. So you will get a copy of the PowerPoint presentation today. And with that, I'd like to kick it off by introducing and throwing it over to Jackie.
Hi, everyone. Elaine, can you hear me okay?
Yes.
Awesome. Hi, everyone. My name is Jackie Aguilera. I'm a labor and employment partner at Morgan Lewis in our Los Angeles office, although as you can probably see, working out of my kitchen for the past 18 months. And basically, I advise and I partner with employers on a day-to-day basis regarding virtually everything employment, whether it's wage and hour, leaves or disciplines or crisis management. I'm there to solve their problems. And for the past 18 months, the biggest problem has been certainly COVID. And I've spent a great deal of time on the impact of COVID in the workplace and the challenges that it's brought our employers. And speaking of which, as of Friday, I pulled the data and it looks like there's about 758 cases COVID related in the employment world filed in California. And the next comparator is New Jersey with about 350 cases. So we're more than double when it comes to employment related COVID cases in California, not surprisingly. So in addition to OSHA and safety claims, which we're seeing a lot of, and Jason's going to cover that during this hour, I think claims relating to employer mandated vaccine policies and reasonable accommodations are soon going to be at the forefront, given what we're seeing, given the requests we're getting, and given that, a lot of our employers want everybody to go back to work and want people back in the office. So thanks to Elaine, this is super timely. Thanks, Elaine, for having us. And now I'll throw it over to Jason so you can meet him as well.
All right. Thanks. And before we do that, sorry, before we do that, I did want to mention, obviously, we have employment lawyers here. This is co-sponsored by the labor and employment section and the privacy law section. My apologies for leaving that out at the outset.
Nice.
Sorry, go ahead, Jason.
All right, thanks, Elaine. Yes, and thanks, Jackie. My name is Jason Mills, and I am a partner also in the LA office. And Jackie and I work together routinely because although we operate somewhat in different worlds, I do the OSHA world and she does a lot of the advice and counsel. There's a ton of overlap with COVID because it is crazy. But my OSHA work before COVID was more of what you would expect in OSHA, handling all of the federal OSHA citations and inspections, and then all the state plans. We have a lot of state plans, or really all state plans on the West Coast. So going up and down the coast, a little bit inland, dealing with, OSHA things like fall protection and machine guarding and what you would picture with OSHA. But then everything just exploded when COVID hit because particularly Cal OSHA decided that they were going to just take charge and put into black letter law a bunch of regulations that were based on what ultimately was a moving target, which ended up being, as probably most of you know, completely impossible to stay on top of and to follow. But that's what I've been dealing with now. It, still some fall protection type work, the standard OSHA work, but it has pretty much been all COVID all the time now for the last 18 months. So that's what I will be able to touch upon today. But thanks for joining us. It's great to be here. And yeah, thanks, Elaine.
Great. Thank you so much, Jason. All right. So for the agenda for today, we're going to cover a lot of topics, and I can already see questions in the Q&A about some of the things that we'll cover here today. But just as kind of a brief overview, we are going to talk about the COVID-19 vaccine mandates and some of the policies around that, and of course, reasonable accommodations that employers might be able to accommodate for their employees. We'll also talk about some of the COVID-19 related costs and benefits to the employees and employers, as well as some of the data privacy implications for the collection of information and the requirements around providing that information to employers. And then last, as Jason mentioned, we're going to cover some of the interesting things that have been going on with OSHA and what some of those look like with respect to the COVID-19 issues here. So with that, we'll go ahead and get ourselves started. And whoops, let me see if I just passed you. And we'll start it off talking about employer vaccine mandates. Jackie.
Thanks, Elaine. So let's get right into it. Elaine, if you have any questions or you want to take any questions, just feel free to interrupt. Starting, I would say, over the past 5 to 6 weeks, we've seen a dramatic increase in mandated vaccine policies over a broad range of industries, whether it's healthcare or entertainment or hospitality, financial services, law firms. We're also seeing a lot of the unions allow employers to mandate the vaccine for their unionized workforce. And the reason behind this is that the EEOC and the California Department of Fair Employment and Housing, those are the agencies that enforce employment laws, have said that employers can mandate the vaccine as a qualification of employer, subject to certain exemptions, which we'll talk about in a minute. And whether or not, a vaccine is in an EUA status is not relevant. So says the DFEH and the EEOC. And we've seen a lot of objections on that. A lot of employees have raised their hands saying, well, it's a EUA status, I'm not going to take it. That's obviously a moot point, at least for Pfizer, now that it is FDA approved. So what we're seeing is kind of 3 buckets of policies that we listed here. We're seeing policies where the employer is mandating it on certain employees. Maybe it's new hires, maybe it's the leadership. So the leadership serves as kind of a role model for the rest of the workforce. Maybe it's customer facing, certainly in healthcare, patient facing. And then we're seeing the softer policies where the employers are saying, you pick, either get a vaccine and show us proof, or get testing, constant testing. And we'll talk about the costs related to that and a bit more burdensome on that one. But then we're seeing a lot more and more just kind of hardcore mandated policies where basically the employer says, you're coming back to work, you work out of our facility. If you have any contact with any human being as part of a job, then you have to have the vaccine, of course, subject to reasonable exemptions. And I guess I would say in my practice, employers really didn't want to be first. They were waiting to see what everybody else did. They were waiting to see what their competitors did. But I think over the past, like I said, 5 to 6 weeks, I think that Band-Aid has been ripped. And we're actually kind of keeping track of all the employers, at least publicly, that are publicly putting it out there in the newspaper. And there are so many employers now mandating the vaccine. So that's becoming more common than not, at least in my particular practice. And I guess if I were to say who the holdouts are, again, what I've been seeing, not across the board, but I see a lot of holdouts for mandating the vaccine in restaurant and retail. But I think that's more a function of recruiting. These industries are back up and open and booming. And it's very challenging getting the more lower level workers to go back to work for these industries. So we're seeing a lot of our clients not want any more impediments to the hiring process. So in those areas, in those industries in particular, I'm seeing less vaccine mandates.
And Jackie, I want to ask you with respect
sure.
to vaccine mandates, I think that raises really one of the important data privacy questions here. And that's, how do you verify vaccine status for your employees?
Well, there's been two ways. One is, you scan, you upload your card, right? So everybody's got the vaccination record card, you scan, you upload it. And just like any medical information, we're telling employers this is confidential medical information. So you can either see it, as an employer and maybe check them off your list and get rid of it forever. Or if you're going to store it, you would store it like you would other medical information, which of course is, no one can see it. It's on a need to know. And, like any other doctor's note or anything like that in a confidential file. I guess the other way we've been seeing clients that are more trusting of their employees is just a self-attestation that the person has been vaccinated or not, or maybe there's some gray area in between. They're starting to get it, or they may get it, or they will get it, something like that. Also, we would treat that as a confidential medical form.
And as a related question, this was brought up in the Q&A, and I think this is a really good one. What about those other employees at the office that may want to know the status of their coworkers? What are your recommendations there with regard to either some type of insignia or something that might indicate the vaccination status of those around them in the office?
Yeah, we are saying no to that. It is my understanding from working closely with data privacy that vaccine status should still be treated confidentially. And, so we have had a lot of employers saying, especially when OSHA came out saying, you can treat vaccinated workers different than non-vaccinated workers in terms of masks. We have a lot of employers saying, could we just put a big, green sticker if they've been vaccinated and red sticker if they haven't? We've advised against that. We are still saying that vaccination status is confidential. To me, it kind of seems a little silly that it is, because it's usually the first question everybody asks, but that's the approach we're taking. And HR can know. HR can be, the enforcement police if somebody's not wearing a mask, and they should be, but it should be like any medical information. It's on a need to know.
Yeah, and from a data privacy perspective, I just want to kind of add on to that a little bit, because generally when we think about confidential information for employees, it does matter how that information is stored. And I know, Jackie, you mentioned that, maintaining that in a way that you would other medical information. I think that that's right. And that kind of goes along with this as well, too, in terms of your employees having some rights to privacy over their medical information. And that is considered medical information under the laws here in California, generally with respect to personal information as well, too. And when we think about personal information in California, of course, and I just want to mention this again from a data privacy perspective, some employers, those that might be covered by California privacy laws, such as the CCPA, the California Consumer Privacy Acts, might have some obligations around providing notice to employees about what they're doing with that information as well, too. So the collection of that information, the storage of that information, and who it's being shared with. So just wanted to make mention of that as well, too.
Great.
Right, shall we move on to the next slide?
Sure. Accommodations. So, this is, accommodations is nothing new, right? I mean, this is pre-pandemic. So while the employers can require vaccines as a condition of employment, the employers have to offer reasonable accommodations. And there are really two, one for disabilities and the other for sincerely held religious beliefs. And again, now that we are returning to work and employers have kind of, like I said, ripped the Band-Aid on these mandated vaccine policies, this is where I am spending a lot of time lately. So let's kick it off with medical. And, medical, the basic law we probably all know is under the Americans with Disability Act and under California law, the employee can request an accommodation. In California, the employee basically has to give the employer a doctor's note. It's got to attest that there's a medical condition, and then it's got to attest that the person needs an accommodation as a result of some limitation stemming from that medical condition. In California, unlike other states and unlike federal law, employers cannot ask what the medical condition is. So that makes this, very challenging in the time of COVID. And again, this is no different than pre-pandemic. Pre-pandemic, right? You've got an employee coming to you, her job involves typing, and she says, look, I've got a disability, I can't really type, so I need an accommodation. And, she goes through a doctor, she gives you a doctor's note. Doctor's note says, yeah, she's got this condition, wink, wink, nod, nod, carpal tunnel, but we're not allowed to say that. And, if you employer provide a, new mouse or a new keyboard, that should do it. And most of the time the employer looks at it and says, yeah, it's not a real, undue hardship. It's not unreasonable. And the employer then provides the equipment, and then the person can go about and do their job. I mean, that's typically how it's worked pre-pandemic. Post-pandemic, it's a little more challenging. Disabilities are not obvious, maybe aside from pregnancy. And certainly the connection between the disability and the requested accommodation, which is here, exemption from a vaccine requirement, is not going to be obvious at all. And so it walks a real fine line in California, because again, we can't ask what the disability is. So because of this, I think employers can safely request further documentation from the employee. The employee has to get it through their doctor, of course. And employers are pushing a little bit on how the medical condition prevents the vaccine. In some cases, does it prevent all three of the vaccines, because they have different components? And I'll say what we're seeing in the labor and employment world is requests from doctors that just, cover the spectrum, right? So we have, we're seeing a lot of, this will cause a severe allergic reaction or an immune reaction like anaphylactic shock. And the employee has suffered that before when exposed to the same components. When I see something like that, it's really hard to question that, right, from a doctor. But a lot of the doctor's notes we're seeing don't pass muster, such as, well, I think the vaccines are still experimental. Or, well, my patient, your employee is having a lot of anxiety about taking the vaccine, or very vague statements from doctors, such as patient has an impairment, and it prevents her from getting the vaccine, or given patient's medical condition, there hasn't been enough research done, and I'm advising patient to hold off on the vaccine for now. I mean, those are a bit vague, and we would push back a little bit on those. Employers are also asking whether the exemption is temporary or permanent, right? And pregnancy is a perfect example. Despite what the CDC says, we're getting a lot of employees asking for an exemption, at least a temporary exemption, because they're pregnant. And I think most employers are granting that. And even the accommodations based on allergies, those can be granted now. And then if and when new vaccines come out, and vaccines are, all made from different components, then the employer can revisit that and see if the employee can take, whatever new vaccine is out. You want to move on, Elaine, to religious accommodations?
Sure. And yeah, just actually before we jump there,
Sure.
I do have a question, because I think that, when you start talking about, asking for additional information and for the accommodations, of course, data privacy experts and attorneys will start, those alarm bells start ringing, right? Because in terms of asking for additional information, at least from a best practices perspective, we always try to limit the amount of information that we get and limit it really to the information that's necessary to make whatever decision is. So do you have any recommendations with regard to limiting the inquiry such that you're protecting those rights and those privacy rights, but still also being able to reach a decision about the accommodation?
Yeah, I mean, it really depends. It depends on what that doctor's note looks like. But I've certainly had employers go back and say, we're not really sure what this doctor's note, why your doctor is saying, it's unsafe for you to get the vaccine. Is it? Have the doctor tell us that it's unsafe for you to get the vaccine because of your medical condition. And so pushback along those lines is all part of the interactive process. Because, and then for the other doctor's notes where it's like, gee, I think it's experimental, and, I'm advising my patient not to get it. I mean, those can be denied. I mean, I would still recommend the employer engage with the employee to see if there's any other information they could provide. But, having just doctors' opinions like that, that's just not a sufficient reason to grant a medical exemption. So it really depends. But part of the interactive process, and I agree with you, the entire exchange, which a lot of times is in writing, should be considered confidential medical information.
Okay, let's move on to religious exemptions. And I know this has been a question that's asked a few times in the chat here. So hopefully we'll address a lot of those questions in the Q&A with respect to this one.
Yeah, I mean, I think in 20 years, I probably had to deal with religious exemption one time. I mean, and now it's like 6 hours of my day. I personally think that a lot of doctors may be very hesitant to put themselves out there and attest that the vaccine is going to jeopardize their patient's life, despite that employee wants that. So as a consequence, I think in my practice, I'm seeing like two or three times as many requests for religious exemptions that I'm seeing for medical. I thought I'd see a lot more medical because pre-pandemic, I mean, that was, kind of the thing. Everybody had a doctor's note and the doctor said you can't do X, Y, or Z. But religious exemptions have just taken over, at least these requests. And, again, the employee has to show that there's a sincere religious belief, that there's a tenet. They don't necessarily have to be in an established religion. So it's really challenging. And it is an area, again, where we engage in the interactive process and the employer pushes back a little because they're testing the credibility of their statements. So, there's, depending again on how they ask the question, we've had employers ask for, statements from their pastor or published statements that their church puts out, or how long, employee, have you been a member of this, church or this sect? What denomination is it? What tenets about your belief actually prevent you from getting the vaccine? And, what we see in response, I'd say more times than not, is a mix of, religion and politics and secular beliefs, social beliefs, which undermine the credibility of the religious beliefs, such as, the government shouldn't be mandating this, so we see a lot of that, right? Or this is my personal choice, or something where they want to mix it in with religion. Jesus says we all have to live moral lives, and it's not moral that you, employer, is forcing me to get this. So again, those would be very suspect. Those we would want to explore further in the interactive process. Other things that, in my opinion, undermine sincerity is when the employee is acting inconsistently with their statement. So, for example, we saw a lot of notes saying, my religion says we can't take any medications or any vaccines. And then when you push a little bit, the employee says, well, yeah, but I take the flu vaccine, or I've taken that, or I take medications or whatever. That's something to push back on if you're seeing inconsistencies. Or my body is my temple, right? We see a lot of my body is my temple. And, I push back and say, well, what things have you done to your body, the temple? What other things have you done to defile your body, the temple? We also see questionable timing on these requests. And it normally happens where there's a medical request made to an exemption to the policy that's denied, maybe because they didn't have a doctor's note saying what they really wanted their doctor to say. And then the employee immediately jumps to a religious exemption. And there's even federal law that supports that in and of itself tests the sincerity of their belief. I would say there's form letters floating around the internet. There's one, if you guys, all of you watching, if you put in Idaho and religious exemption, there's a prominent one from Idaho, and it literally says, use this letter if your employer is requiring you to get the vaccine, right? And employees aren't even tailoring it or removing that legend from it. So, a situation where I would say that's not sincere. We've found a lot of newfound religions, and a lot of, new churches have popped up and have been created as a result of the pandemic. And for a small price of membership, the church will provide a letter to the individual, your employee, and say that the church is against the vaccine. And again, some of the pushback there is, did you pay for this letter? How long have you been a member? Did you have to pay for membership? That type of pushback. And then finally, I'd say we see a lot of letters where the person just says, I'm Catholic, I can't get it, or I'm Christian, I can't get it. And these are typically tied to it's immoral because some component of all the vaccines was tested or developed using aborted fetal cells. And, so putting aside the science behind some of these statements, many times what we'll do is look and see if the particular church has put out a statement on the morality of taking the vaccine, and many, many well-established religions have, including the Catholic Church and the Jehovah's Witness and Seventh-day Adventists and many more. And they've said that they do not take the position that the vaccine is liberal, and that the vaccine is immoral. And there's many, pro-life organizations that have said that as well. So we will push back a little on that and say, you're Catholic, the Catholic Church has come out and said it's not immoral. Why are your beliefs different from what your, church is publishing? And Elaine, with that, I'm on to undue hardship, but if you have questions or want to take any, or should we move on to the next slide?
Yeah, I just actually have one question that popped up in the chat, and it kind of goes to something we talked about a moment ago with respect to, disclosing information. This question is with regard to whether or not employers can share just vaccination percentages among its employees at the company. Because the incentive being that maybe if it's high enough, it'll nudge people to get the vaccine. What are your thoughts on that?
Well, Elaine, I'd probably ask somebody like you that question, but my thought is, I don't see why not. I mean, if you're just saying 50% of our workforce has been vaccinated and you can't identify who they are, I don't see why that's a problem.
Yeah, and from a data privacy perspective, we talk a lot about whether or not you can identify people based on the information that you do have. So it might depend upon the company itself and how big that company is and how much information you're sharing. If you're a large global company with thousands of employees and you share a percentage, that likely wouldn't be enough information to identify people. But if you're a small outfit of 10 employees and you've told them that 90% of your people are vaccinated, then maybe that's another issue there. So I think it might depend upon, but it's a really good question.
Yeah, and especially when the one person in the 10-person firm is wearing the mask, right? and no one else is under Cal OSHA guidelines.
Right.
Agreed.
Okay, let's move on to undue hardship.
All right. So assuming the employer decides that there's a legitimate exemption, whether it's disability or religious, the person got a good doctor's note, the person got a good pastor letter, then the employers move on to undue hardship. And again, just like pre-pandemic stuff, the employers only need to provide accommodations that do not impose an undue hardship. And certain accommodations for this, I mean, look, a lot of employers could provide, right? Wearing a mask, wearing PPE, social distancing, working remotely or working different jobs, all those are reasonable accommodations. Just as a general matter, I think it's difficult in California to establish undue hardship. However, it's going to be really interesting to see how these cases play out, because in California, we've taken such a pro-vaccine stance that, if once these things start getting litigated, I mean, they're litigated by judges, they're litigated by arbitrators, many of whom have gotten the vaccine, maybe they will start granting some of these defenses, right? Or finding some of these undue hardship arguments more credible, certainly than they were pre-pandemic. So, just because of the climate in California. So we'll have to see, and I'm sure we will see soon enough. So basically, undue hardship under medical exemption is that it's got to be cost prohibitive, or it's really disruptive to the workforce. It's, substantially disruptive, extensive. It's hard to meet. Certain industries can meet it easier than others. I know a lot of healthcare industries are taking a strong position on this. And if they're patient facing, they want their employees to be vaccinated, regardless of the ability to wear a mask. So I think we're going to see the undue hardship definitely challenged in healthcare. Others, it's not so easy, right? It's very difficult to say, well, I can't provide you this accommodation if it's, as simple as wearing a mask and staying away from other individuals. And religion, again, undue hardship in California, much harder to establish than under federal law. Under federal law, if it's a de minimis cost to the employer, the employer doesn't have to grant it. But of course, in California, it's got to be significant difficulty, significant expense in order to grant it. And again, we're seeing a lot of this mainly in the medical world, you know, and I haven't really seen the undue hardship made outside of the medical world. And I even asked my colleagues if they've seen it, and we're not really seeing a lot of it. I'm sure it's going to start happening. I guess there's some worlds like entertainment and sports where there are such strict rules that if, you know, for example, somebody who's affiliated with a sports organization, you know, can't take or has a legitimate exemption, the employer might be able to argue there that it would be an undue hardship just because you know, literally the rules of the league. But it's really challenging for employment lawyers to address undue hardship when it comes to medical and religion in California. I've seen a lot of employers think that or say that their employees are, you know, coming up with these doctor's notes and pasture notes and whatnot because they just want to continue working at home. They just want to continue to telecommute. And the employees are very vocal about that and they ask for that. And in those situations, I tell, you know, our clients, then call their bluff. Tell them, look, we're not going to get into the sincerity of your religious belief. We're going to grant you accommodations. You'll be back to work, but this is what you'll be doing. And, you know, you'll be wearing a mask, you'll be wearing PPE, but it kind of, you know, gets rid of that additional argument, I think. And we're definitely seeing a lot of employees not wanting it, particularly lower level employees who like telecommuting and are using this kind of as an excuse not to return to the office.
Okay, so let's move on. I want to make sure we get Jason in here as well too, and our time is already ticking away. So why don't we discuss and talk about employee costs and benefits?
Okay, and I can move very quickly through this. In California, if the employer is going to mandate either testing or the vaccine, the employer must pay for it, meaning they have to pay any out-of-pocket costs if there are any. And for non-exempts, they have to pay for that time off. So going to CVS and the wait time and whatever it is. So employers should be telling their non-exempts to be doing this on the clock. Again, very different than other states. And then, as many of you probably know, especially those listening from the labor section, we have had so many laws in California that impact COVID and COVID-related leaves. And I'll just rattle off a few. There's the California supplemental paid leave that affects California, all of California. And basically, you know, the employees can take off for any reason relating to COVID. They have an 80 hours bank. It's capped at 511, and it's going to expire in September. We have OSHA, which Jason is going to talk about, the emergency temporary standards, where employees, if they're excluded from the work because of some type of workplace exposure, employers got to pay for that time, keep them whole, time and the benefits. And OSHA, I'm sure Jason will correct me, I don't believe puts any time limit on that. So if they're out, the employer has to pay for it. And then moving to the next screen, before there was California supplemental leave, there was a bunch of local, you know, city and county supplemental COVID leave. And, you know, they're very similar, but some have tweaks, some have head counts of 500 and more. Most tend to be 80 hours. A lot of them address school leaves. You know, that was a big deal last year when all the schools were closed and employees had to take care of their kids. And, you know, most don't allow you to ask too many questions. A lot of these leaves are the honor system, and a lot of them will come, you know, unless it gets extended. And it might very well have to do with, you know, the governor recall. Unless any of these things get extended, a lot of them are set to expire on September 30th. And, you know, again, that's a welcome relief to California employees, because it has been so challenging in California to keep up with all the federal and state and local and agency laws that have come out in 18 months, just because of COVID. And then just finally on the last screen here, just quickly, these are just two leaves that are pre-pandemic that apply. It's California paid sick leave. That's from 2014. And then 40 hours of unpaid leave for school-related leaves. We're seeing employees having to take time off with their kids for their kid to get vaccinated, or their, you know, schools requiring testing, or their kids, you know, school closes because of an outbreak. then the school-related leave, again, way pre-pandemic, is another leave benefit that employees would be entitled to. So there's a lot of leave rights, a lot of pay rights when employers mandate the vaccine, and or if employees need to take off for virtually anything conceivable relating to COVID-19. And I think on that, we're on Cal OSHA.
Great. All right, so we'll kick it off to Jason to intro the topic for us.
All right. Yes. So I've been living a COVID-19 safety protocol existence now for not the full 18 months, because this didn't come into vogue until right after Thanksgiving. And for those of you who recall, Cal OSHA, about 7 months in to COVID, saw fit to create an emergency temporary standard, which is it's a big deal. They can't just do that as a matter of course, although they basically did. They announced that they were going to do it, and they did it in such a way that it became effective literally the Monday after the Thanksgiving holiday. So everybody was frantic. Employers were absolutely frantic, trying to figure out what to do with this thing, knowing it was going to become effective that Monday. We actually had led the charge on a lawsuit against Cal OSHA for this. And we fought that for a couple of months. We ultimately didn't prevail on it, but we challenged a number of items on this, starting with whether Cal OSHA could even do it in the first place and whether the record supported that. Ultimately, we were not able to carry the day on that, but I think we did raise a lot of good points. And I'd like to think federal OSHA took some lessons from that when they were figuring out what to do with their ETS. Just another brief bit on the history. So we get the COVID ETS. It, of course, is black letter law that doesn't match what is a moving target. And Cal OSHA was in this position of enforcing something that wasn't always matching what CDC was saying, or in many cases was way more aggressive than what CDC was saying, which was really frustrating. They required a COVID-19 prevention plan. And I think probably a lot of employers on this call, I will say, likely weren't dealing with Cal OSHA too much. Many were, but a lot of office environments just aren't really dealing with Cal OSHA. But all of a sudden, you had this COVID prevention plan requirement that just like straight up applied to everybody. And Cal OSHA, they were kind enough to post a template, and also kind enough to issue over the course of time like 70 different FAQs, or how many they did, which just created more confusion. We had the template for this prevention program that everybody needed to have. And then that actually ended up changing again. So CDC changes its guidance. Cal OSHA was slow to pick up. There was this whole mess. And then Cal OSHA actually amending the ETS, which happened, I believe, back in June. Then we had an amended ETS. The guidance, of course, changed again, but now the guidance doesn't really match what the ETS says. So that's where we are. But in the end, we are required to have a written COVID-19 prevention program. And there is a template of that revised program that exists on Cal OSHA's website. You can find the program. You should just have it and have it just take that template and turn that into a program. And then the next big thing is going to be training the employees on the program and being able to show that, because Cal OSHA has been enforcing this. They've taken a hard angle on this. They pursued it against certainly the healthcare industry, which has been brutal, but everywhere else. So they're going to get reports of employers not following COVID protocols. When they come to inspect, they're going to go straight to that plan, and they're going to go straight to the employee training records. And somehow or other, you need to be able to show that these employees are trained on it. That's a flexible definition, but what you want is something on paper, some kind of record that shows that they've been trained on it. Just across the board, do what you can to make that happen. The revised Cal OSHA ETS, after a lot of back and forth, it was really confusing because CDC had changed its guidance, and then Cal OSHA had this new plan in place that didn't match the new guidance, and then they had to catch up and put in the new guidance. But ultimately, the new guidance, or the new ETS, did start to make room for vaccinated employees. And so you had this kind of carve out for vaccinated employees, but you still had all the testing requirements for the vaccinated or the unvaccinated employees, or even for symptomatic vaccinated employees. And those testing requirements, they've continued to exist, and they've been rough on employers, although I think we're all getting better at it. But like Jackie had already mentioned, the testing has to be at no cost to the employees. and not only at no cost, but you actually have to pay them to go do it. So if you have non-exempt employees and they're getting tested on a Saturday or something, you've got to figure out how to cover that so that they're getting paid. I mean, early on, I think it's better now, but we were doing questions like, what if somebody's gone all day? And, the answer was, well, they're on the clock. So track what they're doing. Keep an eye on them, because you can't have everybody just taking advantage of it. But it really was a challenge. And then, we have here the exclusion from the workplace, which has always been a really difficult issue, because you had to figure out who to exclude. There was really this presumption that anybody who came down with COVID and had a job caught COVID at the workplace, which, as an aside, was a completely unfair presumption, because employers didn't cause COVID and employers couldn't police the ranks at a New Year's Eve party or Thanksgiving dinner. So it was pretty much an impossible standard, but ultimately treating any COVID case as work related, meaning employers had to exclude positive cases, COVID contacts from the workplace, and had to pay them. And that was a big mess trying to figure that out. But it's something we need to keep in mind to this day. When you're excluding somebody from the workplace for because they're an unvaccinated COVID contact, or because they have COVID, you have to maintain their pay and benefits as if they're coming to work, which is a challenge. And as Jackie touched upon, there's not any official cap on that. From Cal OSHA's perspective, if somebody's gone for too long, you start to get into potential disability or some other kind of an accommodation, maybe something that goes beyond just what the Cal OSHA ETS was intended to cover. But that is at least a risk. And so you run into that when you're dealing with these Cal OSHA exclusions. The outbreaks are also a challenge. And I will say a couple. I remember looking at the ETS when it first came out, and I thought the biggest lesson here is do whatever you can to avoid outbreaks, because the requirements are so onerous once it hits. And the ETS has been somewhat revised with the new version, and then with the advent of vaccines, but there are still a lot of requirements. You're moving into the testing requirements and really careful monitoring requirements, and you can get into mask and distancing type requirements. So those are out there for both the outbreaks, which are 3 or more cases within 14 days. And doing that is like a logic puzzle, trying to figure out if somebody is within the contagious period, the highly infectious period. Figuring that out it is truly a puzzle. But if you figure that out, then 3 or more is an outbreak. And then if you get to 20 or more, you're talking about a major outbreak with even more requirements. In the midst of this, you have reporting requirements to both notice requirements to the employees, but then also reporting requirements to the local state health agency per a different law that's out there that is related to Cal OSHA. The return to work, again, a number of different requirements depending on whether somebody had symptoms, they were COVID positive, had the symptoms, but they're pretty strict or pretty clear requirements on when you can return somebody to work. And that comes into play when you're talking about this exclusion leave, when you're paying them for that entire time that they're away. So you're just waiting for this time to tick, or waiting for their symptoms to end if they had them, or if their symptoms don't end, that's where you run into these issues of trying to figure out what to do with somebody who's on what appears to be an indefinite period of paid exclusion leave. And then enforcement. And this is what everybody just needs to be mindful of. And I'd say if there are a couple, really the key takeaways would be what we talked about at the beginning, which is have the written plan and show that everybody was trained on it. To the extent you're trying to determine whether, for example, everybody, you were giving notice to employees because there was a positive COVID case in a work group, which is a term that the ETS uses, or in a work site, whatever you can do to have documented those findings is very likely going to save the day for you if Cal OSHA comes to do an inspection. Cal OSHA struggles when it comes to telling you you did something wrong. If they look at your findings and actually say, no, you're wrong, we think your findings are wrong, that happens. But their easy argument, and I think what is low-hanging fruit for them, is when they can show that you didn't do it at all. And if you don't have documents, they'll just assume you didn't do it and act like that. So that's really what the key is. Find a way to document your findings. So you have the training program, the written training program, you have the written training, the signed training records, or some evidence of the employees having been trained. And then to the extent you're doing any COVID-related analysis or assessment, you're documenting that so you can just hand that over to the compliance officer. They will come out and inspect. It depends on any number of factors, but if you're looking at, say, a serious violation, a serious citation in Cal OSHA, that can be an $18,000 penalty. You get multiple penalties, and even if the money is not the huge factor, there's a little bit of public shaming involved too, because those citations get posted on the federal OSHA website, and that website is searched, and it can be used against you later, and it gets posted whether or not the citation is legitimate or was appealed. So you want to avoid it as much as you can. But as far as enforcement is concerned, if an employee complains to Cal OSHA may come out. If they have some other reason to come out, they'll come out. But they're going to be focused on that program. They're going to be focused on your records, and if they come out, they're going to be looking to see what protocols you have in place and making sure that they follow the ETS. So have that template program, or have that program based on the template in place and just ready to hand over if Cal OSHA shows up. I think, do you have another slide on this, Elaine?
Yes, and there was a lot covered there, Jason. We had a lot of questions coming in during your portion discussing that. I'm going to maybe just go through a couple of those questions before we move on, if that's okay.
Sure.
Okay, just a couple of questions with regard. I know there was discussion about the training of employees and the creation of the prevention plan and program. Does that have to be provided to your employees, the prevention plan? Do you have to actually provide them with a copy of that?
You don't need to just hand them a copy, but you need to have it available at the work site and basically immediately accessible. It's pretty common to have it on like an intranet, something like that, but you need something to show that they have received it and are familiar with it. And so does that mean you end up just giving them a copy? It could, but somehow or other you need to be able to show that they have seen this and are familiar with it. That is pretty common to do that on some kind of web training. I mean, sometimes it's a matter of emailing it or just getting an acknowledgement, which is certainly better than nothing. We see some video trainings where it can be pretty quick. I mean, it doesn't need to be crazy or anything, but pretty quick, explaining that it's out there and what it is and where the employees can find it.
And then what about training folks who are working from home? Is there a requirement to do that?
No, if you have somebody who's purely working at home, then they're actually to this day excluded from that program. So you're good with your employees working from home. No harm in also training them because they might come back to the office at some point, but no, you don't need to worry about the employees at home.
And Elaine, I've also been excluding them from mandated vaccine policies. If they're 100% telecommuting, we've been saying the vaccine policy, there's no reason it would really apply to them.
And then assuming that they stay at home, right? So if they come into the office at some point, I'm assuming that probably changes.
That's right. It's got to be 100% telecommuting, and none of this like, hey, we may call you, you may have to come in once a week or once a month. It's 100% telecommuting.
And then Jason, another question about outbreaks actually, and having people tested. Can you compel your employees to get tested if you have an outbreak?
I mean, it has always come down to this. You cannot physically force somebody to get tested. And this has been an ongoing issue because initially it looked like that's what Cal OSHA was saying. Like you could just pin somebody down and make them get tested. You can't physically force anybody to do anything. So the answer really is no, but what do you do when somebody refuses to get tested? The way that really seems to be shaking out is if you want somebody to get tested, and I think Cal OSHA and the FAQs generally embrace this now, is you need to make the testing available, which is, okay, you are part of an outbreak or you're at the work site, you're part of this group that needs to be tested. We are making testing available to you. It is available to you in this place. You will be compensated when you go get it. And you lead what is the saying? Lead the cow to water, but you can't make it drink, I think, something along those lines. So you're doing everything you can to make it available. And then if they don't do it, you've done what you can do. So that would, if Cal OSHA came asking about that, you want to be able to show that you really made it available. and then you'd be fine.
And kind of as a follow-on question to that, if you have an outbreak or if you have people who have been exposed, providing notice to your employees, can you limit that to those who were within the exposed group of people, or do you have to put out that notice a little more broadly?
Another great question. These are good questions. And that has started out also as a very confusing topic. And the way that ends up is there are these two different definitions in the ETS. There's a working group and then a work site. It's pretty clear that a work site is kind of what you make it. It could be the floor of a building. It could be a cafeteria, but something that you determined is a discrete site. Something that is not the same work site would be a different floor in the building. That's an easy one. And then maybe you're able to break it down within, say, the same floor, or within the warehouse, which can be a little bit more challenging. But ultimately, you kind of get to decide that for purposes of giving notice. But you want it to be justifiable. So we get back to this whole, don't just wing it. If you're going to decide, hey, somebody in our building tested positive, so who do we give notice to? Take a look at the building. Like, where was it? In the cafeteria? Can you legitimately say this is just the cafeteria, or how does that break down? And then record that somewhere, and then provide that notice to whoever was in the cafeteria, to the extent you're able to do that. But that's how I've always viewed that, and have counseled on that. Is you can define your own work site, just be ready to back it up if Cal OSHA asks, and that's why you want to have it in writing.
Great. I think we should move on. We have just a few minutes left, and I know that there's been a lot of questions in the chat about masks. So Jason, you want to kick it off with some masks? Yeah, masks have been just another example of this moving target, and why it's very challenging to regulate something that is literally changing weekly. Masks were required, but then there was this big fight over it because employees were vaccinated, and vaccinated employees shouldn't need to wear masks. Cal OSHA ultimately relented, and the ETS, as it reads, says that vaccinated employees do not need to wear masks. That kind of all got thrown out the window, because then the CDC guidance changed again. So you've got a Cal OSHA ETS that says vaccinated employees don't need to wear masks. And then the guidance changes that everybody should wear masks. And now we have these local orders in place, in LA. We have the CDPH. I mean, basically all the guidance now has changed, which is saying everybody should be wearing masks. And in a number of local orders, they're requiring that everybody wear masks. So kind of the short of it is, right now, everybody should probably be wearing masks no matter what. And in all likelihood, you have some kind of a local order that's telling you that you need to wear masks, even though the ETS says something different. That is just a challenge and a flaw in the system when you're trying to regulate something, again, in black letter law as it's changing. But that's kind of where that stands now. You basically just want everybody wearing a mask. And so this slide is based on the Cal OSHA ETS for the most part, but it's hard to even really talk about it without just saying yes, but there are all these other, there's all this other guidance and these orders out there that address it. So that's where you need to be looking. Even when vaccines came out on the scene, it was pretty clear that what Cal OSHA was trying to do was just force employers to enforce their employees to get vaccinated without actually saying it. And that ends up being, well, at the time it was the easiest approach, but now I think we're going to be stuck in this kind of, unclear guidance on masks for quite a while as we work through the vaccines and I guess get closer to herd immunity. But yeah, that's kind of it on masks. It's tough to get a line on this stuff. So look at those local orders. And then, same with with physical distancing. I mean, they changed those requirements at the ETS with the revised ETS back in June, but then it's still in place, and you should have probably a large number of vaccinated employees. Everybody should be wearing masks. There's not technically a physical distancing requirement. Some of those requirements kick back in with the outbreaks, the 3 or more cases, or the major outbreaks, which are the 20 or more cases. But they did get rid of what were the earlier requirements, which are the physical distancing requirements and the partitions. And so that's what the Cal OSHA ETS still says. And that, so it's less onerous than it was. I will just tell you, though, it is a struggle when the local guidance continues to change. So it's kind of like, do your best.
And if anybody comes asking, you want to show that you did your best. There's that. So record that you're doing your best. Write that down somewhere. That's the key takeaway. Yeah, and screening is still expected. So you want to, I mean, from any number of sources now, because it's all out there. But I get frustrated as I talk about this thing about how the ETS changed, became less onerous, and then the guidance changed again. And so now we have this ETS that doesn't actually match what all of the guidance is, and that is where we are. So just be aware of it, and have everybody wearing masks, and be screening your employees, and doing your best to that, and train on that COVID-19 program in case anybody comes to ask. So yeah, those would be the basics, I think. Yeah, respirators. Cal OSHA loves the N95s. A year ago, they implemented the wildfire smoke requirements, which required everybody to basically be giving everybody N95s all the time. And they like them so much, they then started to basically insist that employers provide them, not really caring about the fact that there were not enough N95s in existence. But this is where we are now. You are required to provide N95s to non-vaccinated employees, which creates this whole issue about, are you identifying employees who are not vaccinated? The answer is yes, but you're not actually like shouting their names from the rooftops or anything. And this is what you're required to do in any event. So you would be providing them N95s for voluntary use. The reason that is significant is because it changes. There are not a lot of training requirements if you just provide it for voluntary use. If you require it, then there's like fit testing and medical evals and a lot of requirements that you want to avoid, which is why they were careful to say it only needs to be for voluntary use. And then you should be encouraging the voluntary use. We have here in bold, the N95, but not the KN95. Another super frustrating thing. Now, those KN95s look just fine to me, but they haven't passed the NIOSH. They haven't gone through the NIOSH approval. So they just aren't approved. So if you get caught issuing or encouraging employees to use KN95s, you will not be in compliance. But we're not in this position now, but it has been the case that, like, look, if you're just out of N95s and need to do something, do what you need to do. But N95s are what technically are in compliance. And we have the rest here, encourage unvaccinated employees to use it. And we talked about the voluntary use. And, really what Cal OSHA wants everybody to do is get their employees vaccinated. So I think whatever you can legally do to that end will probably help move you along.
Yeah, and just in the last couple of minutes that we have here, I want to just address some of the questions that popped up in the Q&A. They're a little broader about Cal OSHA. One of the questions is about whether or not there's any indication as to how long the emergency Cal OSHA standards will remain in effect. Any thoughts on that, Jason?
Yeah, it's actually fairly technical. I'd have to crunch the numbers again, but I believe last time I crunched it based on the last revised ETS, it was going to go through after Thanksgiving. I cannot remember the calculation exactly, but that was my finding. So somewhere around the end of the year, and it's possible they could extend them again, I believe. So right as it stands through the end of the year.
And then maybe looking into the future a little bit with respect to the Cal OSHA working group on COVID, any expectations that might come out of that?
I think we're just going to continue to see everything get pared down, but not until we're past this Delta variant. And I think we're going to see a bit of a holding pattern right now. Eventually, we're going to see it get pared down or just go away, but it's not until we get to this herd immunity. So I anticipate us basically staying where we are for the foreseeable future.
Okay, we're nearing the end of the hour. I just wanted to thank our panelists, Jackie and Jason. We had a lot of questions that we weren't able to get to today, just barring the time. Obviously, this is a topic that's very interesting to a lot of people, and with all the changes and everything that's going on, I know everybody, and I am appreciative of hearing from the both of you. So thank you, everyone. Also, one quick thing as well, too, the slides from today's webinar will be made available to everybody in attendance. I believe they are going to be emailed to everybody after the presentation today. So with that, Jackie and Jason, thank you. And if you have any parting thoughts, please feel free to share them.
Follow that COVID protocol plan. That's all. Thanks, everybody.
Check those local regulations in addition to the state. That would be my parting advice. And thanks for having us, Elaine.
Yeah, and from a data privacy perspective, always think about what you need that information for and whether or not you need it when you're collecting it, and try to minimize that in order to minimize your company's liability. So, all right. Well, thank you, everyone. Appreciate everyone being here in attendance today. And until next time, and thank you to the labor and employment section and privacy law sections for putting this on today.
Thanks.